Let's see. You better watch the way you breathe around me, or that breath be your last, boy. Smith & Wesson 45, put a hole in his heart, better not play with me. Killers, stay with me. I shot at his mommy, now he no longer mentioned me. We believe that Mr. Williams doesn't sing about random theoretical acts. He sings about gang acts that he's a part of or his gang participates in. Following that, Your Honor, in the same year, Act 96 on 8/8/19, Mr. Williams posted on Instagram a post, if you will. It said, IFN or YFN, if ain't like what you do for your mother and your kids, I would have killed you. And that was tagging YFN Lucci. Now, I'll go back and I'll get to that later. But this year, a YSL member attempted to kill Mr. Rayshawn Bennett, a.k.a. YFN Lucci, at the Fulton County Jail. That's on video as well. And we can tie that to the gang, and I'll get to that later. On Act 97 from 9/16/19, Mr. Williams posted a video called Just How It Is. There were lyrics in that one as well.
What number is that, sir?
97, I'm sorry.
I'm sorry.
And it said, last N-word tried me, almost got popped at Lennox. Asked the cops, asked the detectives, they know all the business. Asked the cops and detective all the jurisdictions. Gave the lawyer close to $2 million. He handles all the killings. Mob business. We know to kill the biggest cats of all the kittens. Also, it should be noted that it's alleged that Mr. Donovan Thomas was the head of the Inglewood family criminal street gang at the time. And irrespective of his position that he might have had in the gang or not in the gang, Mr. Thomas didn't deserve to get gunned down on the road in Atlanta. Position or Act 102 judge from 3/12/20. Mr. Jeffrey Williams is in a conversation with Mr. Huey, also a defendant in this indictment. Now, let me set this up, Judge. And you heard part of this last time, that there was a theft of a car by someone in the gang, Mr. Huey, and it belonged to I believe, a manager of Mr. Williams. Mr. Williams was upset to find out that it was, and he basically texted his folks to say, give it back. Now, in that, he responds to Mr. Huey, says, if he don't take it back, he gonna die. Followed that, Mr. Huey basically was begging for his life in the conversation. It's very clear that he believed that statement by Mr. Williams. In Act 127, Your Honor, from 2/4/21, Mr. Williams is in a conversation with other listed on the indictment, that he stated, YSL rule the world, kid. 24 million on an N-word's head. Y'all just start bringing me the money. Man, y'all stop playing with me. That was in reference to gang activity and basically evidence that he is in charge and all the money goes to and flows through Mr. Williams. On Act 130 from 4/16/21, Judge, there's a social media post titled Slatty, SLATTY, lyrics stating, I killed this man in front of his mama, I guess sister and his cousin. I shoot out, kill him, not leave a trace. It says, you think you a gangster, you got a pistol, look at my triggers start itching. YSL, we going overboard. And again, YSL is a direct reference to Young Slime Life, the criminal street gang. Act 131 on 4/16 of 21. There's a video released called Ski, SKI, with lyrics stating, I fuck with slats. Slats being basically slang life forever. We come to eat rats. I came with some piranhas. I tote an FN, a reference to a handgun. And in that one, which is interesting, Judge, which you'll hear in the evidence of this case, is this is a hybrid gang. This gang isn't pure bloods. There are rolling 60s in it, Crips. There are 30 deep. It is a combination of many different gangs to form this gang. In Act 132 from 5/13/21, Judge, a conversation where Williams asks the others in the conversation, y'all ain't beat them up or shot them yet? Y'all N-word getting soft. And I believe that's directing the activity of the gang to stand up for the reputation of the gang and not be disrespected. Your Honor, in Act 139, I'll miss 139, Judge.
Context. 132. What's not what he said.
Acts 150, Mr. Huey, which I spoke of earlier, had gotten out of jail. He had communicated with Mr. Williams, basically stating, and this is Mr. Huey, you know I'm ready to handle the business and go sit down if I got to about any one of y'all on my mama. Sit down is a reference by the gang, because I'm willing to go to prison for you. I'm willing to do time for you. In Act 155 from 12/31/22.
And
12/31/21, Judge.
and that's predicate of what?
It's an overt act, Judge. There was a photo released by Mr. Williams with him wearing a YSL pendant with basically with taking his finger under his nose like this, Judge, which is a gang sign from YSL. That's one of their signs. When we watch the videos, you'll see that a lot, Judge. Judge, in Act 156 from 1/16/22, defendant released a video, and why we think this is important, Judge, is because the gang signs, mostly done by Mr. Williams, are YSL gang signs, Young Slime Life. They may argue that it's Young Stoner Life, but in this video, Mr. Williams flashed a Bloods sign, not a video, not a YSL sign, a Bloods gang sign. He's also got a photograph where he's got a red B right about here on his chest, Judge, which is a common Bloods tattoo. On 3/9/22 in Act 172, Williams posed for a photograph with the caption, Slat Business YSL 4L for Life. Judge, we have proffers that from gang members, and some on the indictment, some not, that Mr. Williams is the leader of the gang. He directs the gang activity. This is we see through the indictment. There are numerous murders. There are numerous armed robberies. There are numerous attempted murders, shootings. Just like, again, I spoke about the Gaudis, about the criminal gang, mafia families out of New York. The bosses themselves never got their hands dirty. The issue here is, Judge, is Mr. Williams directs and has directed all of these individuals, Judge. And he recruits people continuously, Judge. We have a proffer, Judge, even from the mother of one of the defendants in this indictment who told us that Mr. Williams does the community events in order to recruit more people, that her son was recruited by money, shoes, clothes, because they didn't have anything. And now her son's, by her statement, is in jail for the rest of his life. And that's the mother from one of the defendants on this case. Judge, Mr. Williams essentially is YSL. Everybody else is a follower. There are leaders. We said Mr. Kitchens, Mr. Greer, are also leaders. But the leader, the top dog, the most dangerous man here is Jeffrey Williams, because he doesn't have to get his hands dirty. He has others to do his business. Judge, in an analogy, who found the others danger to the community, danger to commit additional felonies? And I would say, of the least of them, you found them dangerous. This is the most of them. This is the one that you see the shadow in the back of the room. He's the one directing traffic. He is the one that we're all afraid of. He's the one that's king slime. He's pulling the shots. He is the most dangerous of the 28, Judge. And I implore you not to grant him a bond. He's dangerous. The setup they've given to you is actually going to be less control, not more. If he gets a burner, Judge, and the court may know this, a lot of the communications that Mr. Williams is on FaceTime, because it's not traceable, it's not trackable. And we know that to be their MO. He gets a burner, he gets in there, he runs his gang from inside, and he won't get that, and no one's going to throw his cell. I know what the investigator said, with all due respect. That's not the jail. That's their job. It's not the job of 24 officers being paid by Mr. Williams. That's not their job. The job is the sheriff of Fulton County or any other sheriff where our sheriff decides to put Mr. Williams. That's their job. He is dangerous. And I normally don't do this, but I don't hesitate in this case. Respectfully, Judge, I believe if you give him a bond, we're going to have more witnesses in danger that we're going to be missing. I believe he's that dangerous, Judge. Thank you.
All right. Court's permission, if I may offer rebuttal, just a few closing statements to.
All right, Mr. Adams.
Thank you, Judge. Thank you, Your Honor. There's a lot that I want to say to the court. I'm going to finish my argument by referring to exactly what we're supposed to be doing here, which is talking about the law briefly. And I won't take too long because I know Mr. Steele has done an excellent job thus far of presenting what the court needs to have in front of it in terms of considering suitability of bond. But I want to start where the prosecution left off and talk to the court briefly about why it's so dangerous to have the state make a presentation in a manner that it did. This statement, and this is kind of emblematic of the entirety of the state's argument. If you give Mr. Williams a bond, that I'm afraid there are going to be more witnesses who are in danger or more witnesses who are threatened or something to that nature, right? And the thing that's so disingenuous about that statement is that just about 10 minutes or 15 minutes into in the prior argument, Mr. Gary conceded that there is no evidence, there is zero evidence that there are any threats being made that can be tied in any form or fashion to Mr. Williams.
Well, I think that's not the statement. I think he said as well that there are proffers from other gang members that he's the leader of the gang, he's dangerous, you cross him and he'll kill them or kill their family. So there is something the court has heard thus far. If
we're breaking it down, Judge, what Mr. Gary was talking about in that regard is what I I presume he believes will be evidence in the case. Now, in talking about the bond, in talking about whether or not there is any evidence before the court, right? And there was this discussion earlier.
Well, that's a problem. I mean, I take you all on your word for it, Mr. Adams. I mean, it's a proffer. I mean, it goes to the state's contention of whether or not he's a danger to the community. One of the things I have to look at in one factor. So whether or not I take it is value, certainly is dependent upon what I in terms of weighting the situation, weighing what's been proffered thus far.
And I understand that. What I would ask the court to pay close attention to and to keep in mind is that allegations put forth by the state in regards to what they say is evidence that is going to be forthcoming are exactly that, allegations that have not been vetted, that may or may not be accurate, that will come before this court, presumably during the course of a trial. But for purposes of the bond, and for purposes of whether or not Mr. Williams, if given a bond, is going to return to court to face process of the court, to face these charges, whether or not there's evidence that goes to his guilt or innocence, whether he is guilty or not guilty of these charges, is not what is before the court. So
you're absolutely right. You don't have to waste your breath on that.
Right.
I'm very familiar with Mr. Williams and the other co-accused presumption of innocence, and the court deems them as being innocent of these charges. I'm asked to pass on bond, and the bond is predicated on, on the issues that the appellate case law tells me I need to kind of consider. So
let me then address some specific things that Mr. Gary said, that the state said in their argument.
All right.
The state started their argument by saying that this is all about money, and to be quite honest, that's a little bit of that's a little insulting, because the inference is that if Mr. Williams has means or has resources, that is a bad thing, that he is trying, in their words, to quote, "I can buy a bond," is what the state said. They said he wants to, quote, "pay his way out of jail," is what they said.
Well, I think that they're saying, it's a factor, is resources of the accused in this particular circumstance, but it has to be taken into context with other things. So I'm not saying that. I understand their assertion in that regard, but it's more so the court's going to consider it from an issue of its context of other things.
Yes, sir. And one of the things
and wealth being able that you can make bond. I mean, so I understand that.
And that's precisely the point. The fact that Mr. Williams may have means or may have resources by which that can be brought to bear. Those resources are being brought to bear for purposes of assuring the court of his reappearance. Because the other way, of course, to look at it, as you've heard from some of the witnesses, is that there's a lot at stake. That if he does not reappear in court, that there are financial resources, there are people's well-being that are put at financial stake because of that, and that is certainly something the court can consider in regards to whether or not he would reappear. Now, what I also think is an inappropriate argument is that the witnesses who took their time to come in here and testify about their knowledge of Mr. Williams, about his background, about what he's done, about his ties to the community, about his investments in the community and so forth, and his employment, his financial status, his jobs. They took their time and came in and testified. I would submit to the court honestly about their knowledge to you about Mr. Williams. I do not believe that there's anything to suggest that anyone who came in here and testified came in because of a financial motive, that they have something to gain or something to lose financially by coming in here and speaking honestly to the court about their knowledge of Mr. Williams, which is what the court needs to make its decision.
I'm taking it from the standpoint of he has significant ties to the community.
And that is, thank you, Judge. And that is exactly what I would suggest that information was. That is what was presented to you, that he has strong ties to the community that weighs in to his benefit if he, as the court considers, bond. Now, one of the things that the state referenced, that the state asked you to consider, was whether or not he is a flight risk. And I want to roll this into a discussion of the bond hearing that was held before Magistrate Judge Wolf some weeks ago.
Yeah, I'm going to mark that as Court 2 for purpose of the motion. That was done on the 11th of May and filed into our e-file system, or Odyssey, I should say. So I'll make that part of the record.
Yes, sir. That was on a Wednesday. I was present for that bond hearing. I was there, and I can tell the court that that would have been 2 days after Mr. Williams was originally arrested. He came for a first appearance. I'll tell you that the court, Magistrate Judge Wolf, heard argument from both sides as to the suitability of bond. And I will tell you as an officer of the court that Magistrate Judge Wolf was concerned about the fact that the indicted case was already assigned to you, that there was someone that Mr. Williams was already assigned to on a separate case, a separate but related case. And there were discussions about whether or not, because he had resources, he was a flight risk. Because he had money, he had the ability and the wherewithal to leave. And Judge Wolf, I will tell you, in denying the bond, which he did, essentially indicated that he asked him very many questions about whether or not there was a bond hearing scheduled in front of Your Honor, and whether or not you'd be considering the issue of bond on the indicted case, and that he would defer, that he was going to deny bond at the time, but he was going to defer to Your Honor because the other case was in front of you and because that case was related. And so it is my impression from the hearing on that day and the denial of bond that the court anticipated that you would be making the larger decision as regards whether or not Mr. Williams receives bond on both matters or not. And of course, both matters are in front of you now. Now, there is, in regards to flight risk, whether or not he's a flight risk and some of what the state has said, there is no indication that he is a flight risk. Mr. Gary referenced a failure to appear, and yet conceded that he doesn't know anything about that failure to appear.
It's for a traffic offense. It's of diminished value to the court, but I'm more interested in the access to private jet.
Yeah,
at PDK in DeKalb.
And so that's the thing, because our suggestion to the court is that he be placed on house arrest. That he be placed on house arrest. That he have an ankle monitor. That there are post-certified law enforcement officers who are responsible for making sure he complies with the court's conditions. There is no suggestion on our part that he be allowed to fly by way of private jet, commercial jet, helicopter, or anything of that nature. And so the argument that because he has resources, he has in the past has had access to a private jet, that is something the court should be concerned about. We would suggest to you that is not something for you to consider, because we're not asking that he be allowed to have that access. You heard from Mr. Middlestat, who indicated that what would happen essentially is if the court were to graciously grant bond for Mr. Williams, he would be released from where he is now. He will be transported by law enforcement officers to the location that the court has indicated, and he will stay there. And if he is to leave to come to court, the only reason that he would do so under supervision and under guard of law enforcement officers. And when Mr. Middlestat testified, I think he was clear and he was deferential to the court in regards to what the requirements would be. These are going to be post-certified law enforcement